I want to walk you through something that's often misunderstood in our national conversation: how immigration enforcement actually works under our Constitution, and why our legal system treats immigration violations differently from other offenses. This isn't about policy preferences. This is about understanding what the law actually says, how our courts have interpreted it, and why this system has been upheld as constitutional for over a century. Let's start at the beginning, the Constitution itself. Article 1, Section 8 grants Congress the power to establish an uniform rule of naturalization. This is explicit. The founders gave the federal government, specifically Congress, the authority to determine who can become a citizen. But what about who can enter or remain in the country? The Constitution doesn't use the word immigration at all. So where does federal immigration authority come from? The Supreme Court answered this question definitively in a series of cases beginning in 1889 with the Chinese exclusion case. The court held that the power to regulate immigration flows from national sovereignty itself. Every sovereign nation has the inherent right to determine who may enter and remain within its borders. This isn't just a power granted by the Constitution, it's a fundamental attribute of being a sovereign nation. The court has consistently held that immigration control is so integral to national sovereignty that Congress has what's called plenary power, meaning broad, sweeping authority over immigration. This power has been reaffirmed in dozens of Supreme Court cases over 135 years. This isn't controversial legal theory. This is settled constitutional law. Why immigration violations are civil, not criminal. Now here's where it gets important to understand the distinction. When someone overstays a visa or remains in the United States without authorization, they have violated immigration law. But, and this is crucial, that violation is civil, not criminal. Think of it like a building code violation or a breach of contract. It has legal consequences, but it doesn't make you a criminal. You won't go to jail. You won't get a criminal record. What happens is removal, deportation, which is a civil remedy, not a criminal punishment. Now, I need to be precise here. Unauthorized entry, physically crossing the border without inspection, can be prosecuted as a federal misdemeanor. That's a criminal offense. But even when someone is convicted of that crime and serves jail time, the subsequent removal proceeding remains civil. Why does this matter? Because the consequences are different, and so are the procedures. In criminal cases, the government must prove guilt beyond a reasonable doubt. You get a jury trial. You get an appointed attorney if you can't afford one. These are your Fifth and Sixth Amendment rights. In civil immigration proceedings, the standard is lower. Preponderance of the evidence, more likely than not. There's no jury, and there's no constitutional right to an appointed attorney, though you can hire one. Some people ask, how can the government deport someone without giving them a free lawyer? The answer is found in constitutional law. The right to appointed counsel comes from the Sixth Amendment, which specifically states, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. Criminal prosecutions. Deportation proceedings aren't criminal prosecutions. They're civil administrative proceedings. That's not a loophole, that's the constitutional text. Let's talk about who actually decides these cases. In criminal court, you appear before a federal judge appointed under Article 3 of the Constitution. These judges have life tenure and can only be removed by impeachment. This independence protects them from political pressure. In immigration proceedings, you appear before an immigration judge. These are administrative judges who work for the Department of Justice, specifically the Executive Office for Immigration Review. Why the difference? Because immigration is fundamentally an executive function. The president, through the executive branch, enforces the nation's borders. Congress writes the immigration laws, but the executive branch implements them. Immigration judges apply the law that Congress wrote, the Immigration and Nationality Act. They conduct formal hearings. They take evidence. They make findings of fact and apply legal standards. Their decisions can be appealed to the Board of Immigration Appeals and then to federal circuit courts. But they're not criminal court judges because they're not presiding over criminal trials. They're administrative officials resolving civil matters. This structure isn't unique to immigration. Many areas of law work this way. Social Security disability claims, administrative law judges. Patent disputes, administrative proceedings. Tax disputes, tax court. The Constitution permits Congress to assign certain matters to administrative agencies rather than requiring all disputes to be heard in Article 3 courts. The Supreme Court has upheld this for immigration specifically, recognizing that Congress has broad authority to structure immigration enforcement. Let's walk through what actually happens when someone is apprehended. Immigration and Customs Enforcement Officers, ICE agents, have statutory authority under 8 U.S.C. Section 1357 to arrest individuals they have reason to believe are removable from the United States. Notice that standard, reason to believe. That's lower than probable cause, which is required for criminal arrests under the Fourth Amendment. Why? Because immigration enforcement exists at the intersection of two constitutional principles: the Fourth Amendment's protection against unreasonable searches and seizures, and the federal government's plenary power over immigration. The Supreme Court has held that at the border and its functional equivalents, Fourth Amendment protections are diminished because of the sovereign's right to control who enters. Even inside the country, immigration enforcement has some latitude because removal isn't punishment. It's the enforcement of a civil determination that someone lacks legal authorization to remain. Once arrested, an individual may be detained pending their removal hearing. For certain categories, people with criminal convictions, those deemed security risks, detention is mandatory. Others may be released on bond. Here's where people often ask, how can you hold someone without charges? But there are charges. The person receives a notice to appear, a charging document that specifies exactly why the government believes they're removable. Maybe they overstayed their visa. Maybe they entered without inspection. Maybe they violated the terms of their status. The charges are specific. What's different from criminal detention is that the burden of proof is lower and the proceedings move differently. But there is due process. There is a hearing. There is an opportunity to contest the charges. At the hearing, an immigration judge presides. The individual has the right to be represented by an attorney at their own expense. They have the right to present evidence, to call witnesses, to cross-examine government witnesses. The government bears the burden of proving by a preponderance of the evidence, more likely than not, that the person is removable. The individual can contest the charges. They can apply for relief from removal if they're eligible, asylum, cancellation of removal, adjustment of status, whatever statutory relief might apply. The judge makes findings of fact and conclusions of law. If the person is found removable, a removal order is issued. That decision can be appealed to the Board of Immigration Appeals and then to a federal circuit court. So there is judicial review. There are multiple layers of review, but the proceeding itself is civil and administrative, not criminal. Now let's address the fundamental question. Is this system constitutional? The Supreme Court has said yes, repeatedly and consistently. Here's why. First, congressional authority. Congress has constitutional power over immigration through its naturalization power, its power to regulate commerce with foreign nations, and the inherent sovereignty of the federal government. Congress chose to make most immigration violations civil rather than criminal. That's within its authority. Second, executive enforcement. The president has constitutional duty to take care that the laws be faithfully executed. Enforcing immigration law is part of that duty. Establishing administrative procedures for doing so is constitutionally permissible. Third, due process. The Fifth Amendment guarantees that no person shall be deprived of life, liberty, or property without due process of law. Immigration proceedings provide due process, notice, a hearing, the right to counsel at your own expense, the right to present evidence, the right to appeal. The Supreme Court has held this satisfies due process for civil removal proceedings. Fourth, limited judicial review. While federal courts can review immigration decisions, Congress has limited that review in certain ways. The Supreme Court has upheld these limitations because Congress has broad power over immigration and can set the terms for judicial review of administrative decisions. Some argue this system is too harsh. That's a policy debate. But constitutionally, the courts have consistently upheld it. What about the founders? What would they have thought? Here, we need to be historically honest. The founders didn't create a comprehensive immigration system because large-scale immigration regulation as we know it didn't exist in 1789. But we can look at what they did establish and what they believed. They gave Congress power over naturalization, clearly indicating federal authority over citizenship. They understood national sovereignty. The concept that a nation controls its borders would not have been foreign to them. It was assumed. In the early republic, the Alien and Sedition Acts of 1798, passed just 9 years after the Constitution was ratified, gave the president power to deport aliens deemed dangerous. This was controversial for many reasons, but the underlying premise that the federal government had authority to remove non-citizens was not seriously disputed. Throughout the 19th century, as immigration increased, Congress passed increasingly detailed immigration laws. The Supreme Court upheld them based on inherent sovereign authority and Congress's enumerated powers. The founders created a constitutional structure with 3 branches and enumerated powers. They gave Congress authority over areas touching immigration. They made the president responsible for executing the laws. They established federal courts to interpret the law. The immigration system we have operates within that structure. Congress writes the laws. The executive branch enforces them through administrative proceedings. The courts review those decisions within limits Congress has set. That's separation of powers working as designed. Let me address some common objections directly. How can deportation not be punishment? You're forcing someone to leave their home. The legal answer is that deportation is not intended as punishment for wrongdoing. It's enforcement of the civil determination that someone lacks legal status. The purpose isn't to punish, it's to enforce immigration status. You might say that's a distinction without a difference, but it matters legally. Punishment requires criminal proceedings and criminal protections. Deportation is a civil remedy. Why don't people get free lawyers? Because the Sixth Amendment right to counsel applies to criminal prosecutions. This isn't a criminal prosecution. Many civil proceedings don't provide appointed counsel. Divorce, custody disputes, eviction hearings. The Constitution doesn't require it for civil matters. Administrative judges aren't independent like federal judges. True, but administrative proceedings are used throughout government. Congress has discretion to assign matters to administrative agencies rather than Article III courts. The Supreme Court has approved this structure for immigration. The system seems stacked against immigrants. That may be a fair policy critique, but it doesn't make the system unconstitutional. Congress could provide more protections if it chose. The Constitution sets the floor, not the ceiling. Here's the bottom line. The United States has a complex immigration system that distinguishes between criminal violations and civil violations. Most immigration violations, overstaying a visa, remaining without status, are civil matters handled through administrative proceedings. These proceedings provide due process, notice, hearings, the right to counsel at your own expense, the right to present evidence, appeals. The system operates under congressional authority to regulate immigration, a power the Supreme Court has recognized as fundamental to national sovereignty. Administrative judges apply the law Congress wrote. Federal courts review their decisions within the limits Congress established. This structure has been upheld repeatedly as constitutional. It reflects the separation of powers. It operates within the framework the founders created. You can debate whether the laws are wise. You can debate whether enforcement is fair. You can argue Congress should change the laws, provide more protections, fund more judges, or give people free lawyers. Those are legitimate policy debates. But the system itself, the constitutional authority for immigration enforcement, the use of civil rather than criminal proceedings, the administrative structure, is legally sound. It's not a loophole. It's not a workaround. It's Congress exercising its constitutional authority over immigration, consistent with over a century of Supreme Court precedent. Understanding this distinction between what's constitutional and what's preferable, between legal authority and policy choice, is essential to having an informed debate about immigration in America.